So much, Professor Schindler. My task is to review the past year's cases in the United States Supreme Court. And I just want to say a word about IP cases in the court in terms of finding out about them. You may all be familiar with this, but the U.S. Supreme Court today is probably the most transparent court in the world in terms of their business in finding out what they do. Every Friday there is posted on the U.S. Supreme Court website the oral arguments from the previous week. You can listen to the audio, you can download the transcripts. All the opinions are available on the Supreme Court website. All the briefs are available on other websites. The Library of Congress, for those of you who don't use it, has a law section and a law site in which all previous opinions are available, briefs in those opinions. So the U.S. Supreme Court is the easiest and most transparent court in the world to follow in terms of how it conducts its business and what's going on. And for those of you who don't listen to them, having the oral arguments available has added a dimension to understanding the court that we never had before, because the justices in their questions indicate things that never get into the opinion. And I personally believe and have said in the United States that if you practice in any area in which the Supreme Court is relevant, it is beneath the standard of practice to not listen on a regular basis to the oral arguments at the court. There's some important things to say about the U.S. Supreme Court and patent law. The first is that there's now an enormous conflict between the United States Supreme Court and the Court of Appeals for the Federal Circuit. The first case that I will talk about, the Myriad case, is the second time in 2 years that the U.S. Supreme Court has reversed the Court of Appeals for the Federal Circuit unanimously by a 9-0 vote. And for the court by 9-0 2 years in a row to reverse the Court of Appeals for the Federal Circuit is really sending a message. The judges on the Court of Appeals for the Federal Circuit have not been shy about expressing their opinions about the United States Supreme Court and its ability to handle patent cases. But this is a very much part of the existing patent scene in the United States. And the U.S. Supreme Court, of course, is critically important because of the size of the American market, but also because of the way it handles patent opinions. They're like thunderbolts from Zeus. You don't find the kind of opinions you see in the Federal Circuit, carefully analyzing claims. They're very broad opinions, very, very sweeping. And the Myriad case illustrates that, and it also illustrates one other thing that's very important in American patent practice today, and that's affecting the court, which is the extent to which non-traditional, non-patent actors, people who previously have not been involved in the patent system, are asserting their values against the values of the patent system. Myriad involved the isolation of the BRCA genes, 2 genes, BRCA1 and BRCA2, which are diagnostic tools for breast cancer. They're markers for the risk of breast cancer. What Myriad did was 2 things. They isolated the genes themselves, and then they created complementary DNA, simply of the exons, the operative part of the DNA string, and received patents on both. This case was heard twice by the Court of Appeals for the Federal Circuit, once where it upheld the patents on both the DNA, the isolated DNA, and on the complementary DNA. After Mayo versus Prometheus, the last case a year ago that the Supreme Court reversed, it remanded back the Myriad case to the Federal Circuit, which didn't blink and upheld as valid the patents on the DNA and on the cDNA as well. It came up to the United States Supreme Court, and the United States Supreme Court dealt with it as it was below, as an issue of patent eligibility. This is not a question of novelty or utility or non-obviousness. It's basic patent eligibility under Section 101 of the Patent Act, which provides that what can be patented, any new and useful process, machine, manufacture, composition of matter, or new and useful improvement thereof. And this was clearly a case involving composition of matter. But the court has 3 exceptions to that statutory language: laws of nature, natural phenomena, and abstract ideas. And it unanimously decided that the isolation of the DNA itself was a law of nature or a natural phenomenon and was not patent eligible. It didn't decide on the basis of novelty, that it was not patent eligible. It did, however, find that the cDNA, which had resulted from the process of taking out the exons and creating the complementary DNA, was patent eligible. It's not clear what kind of practical effect that has, because anyone who wants to compete in the marketplace and do DNA tests can simply avoid using the cDNA and use the original isolated gene and come to exactly the same result. Now, what are the basis? Why did the Supreme Court come to this opinion? This is a classic case of non-patent actors having impact on the patent system. The plaintiffs in Myriad were represented throughout the trial court, circuit court, and U.S. Supreme Court by the ACLU, the American Civil Liberties Union. To my knowledge, the American Civil Liberties Union has never gotten involved in an area of patent law before. But this was seen by them and by the people who were supporting them as an issue of access to medical care, especially women who faced the price of about $2,000, which is what Myriad was charging, in order to get the diagnosis of their risk of breast cancer, or if there were other risk factors to get it confirmed. And so this was seen as an access issue involving an old-fashioned word that we thought we'd taken out of the patent law, but which has come back, which is questions of morality. And it was the ACLU that represented and ultimately won the case on that basis. Now, of course, there were numerous amicus briefs, an endless number of amicus briefs filed on behalf of the biotechnology and pharmaceutical industry, all pointing out that the patents were essential to promote innovation and investment that created the technology that gave us the isolated DNA gene, and that without the investment, there would have been no isolated DNA gene for there to be a battle over access about. Myriad did not make that case very well. It let this go forward. It treated it as a technical patent case. It did not run a public relations campaign saying, you ought to know the only reason this test exists is because we invest hundreds of millions of dollars in developing the methodology, and without being able to patent these kind of results, there will be no future inventions. Myriad failed to make that case, and the U.S. Supreme Court ignored that, basically said it makes no difference. It makes no difference that this is a groundbreaking discovery. It makes no difference in its brilliance. It's a law of nature, and therefore we are going to find that it's not patent eligible. This, of course, has totally shaken up the biotech industry in San Diego and elsewhere. Real questions combined with the Prometheus case about what kind of inventions will be subject to patent protection. And the patent protection, as anyone who has ever evaluated an investment in any biotechnology company knows, the existence of patent protection is essential to the project going forward. And I don't think there's any doubt but that if Myriad and its investors had not had opinions about patentability of the isolated DNA gene, that there would have been no investment and no development of the isolated BRCA1 and BRCA2 gene. But the court did not consider investment. For the investment motivations, they considered it irrelevant. For me, what's so interesting about this is how investment is so important. When James Watson and Francis Crick wrote their famous short letter to Nature magazine, setting out the DNA molecule in 1954 and suggesting it might be the basis of replication and inheritance, they didn't need any venture capital. All they needed was Rosalind Franklin's X-ray crystallography, which was of minor cost. They needed no money, they needed no venture capital, they needed no investment. The isolated DNA gene would never have been discovered without mammoth investment. And so the question that the U.S. Supreme Court has to wrestle with ultimately is investment critical in terms of evaluating patent rights, or do we simply assume it's the world of 1954, or the world of Albert Einstein, who didn't need venture capital to write about general or special relativity, or Max Planck to talk about quantum mechanics? The court faced a similar issue, interestingly, in the second important patent case of the term, Bowman versus Monsanto. Bowman versus Monsanto involved the patent and usefulness and utility of Roundup Ready soybean seeds. What Monsanto had done was patent a group of soybean seeds it called Roundup Ready that were immune to herbicides and insecticides, the glyphosate spraying on the fields that kills the pests and the herbicides and other things. They originally sold some of the seeds to Bowman, who was a planter. When Bowman bought the seeds, he signed a license agreement. He agreed that he'd only use the seeds one season. He agreed he'd only use them for planting, and he agreed he would not use them for any replication. And it was part of the license to Bowman for use of the seeds. The case does not involve that license. What the case involves is Bowman later went to a granary, and he bought from the granary a bunch of soybean seeds that were manufactured by Monsanto. He didn't know whether they were Roundup Ready or not Roundup Ready. He just bought the group of seeds. He planted them, and he sprayed the field with glyphosate. Most of them died. Some of them survived. He knew then those plants were the Roundup Ready seeds that had the immunity from glyphosate, and he then took those seeds and he planted another crop. Well, Monsanto sued for patent infringement, said, we've got the patent and you can't use it for another crop. Bowman's defense, as a matter of logic, was perfectly straightforward. He said, this is a question of patent exhaustion. I bought the seeds, and under standard doctrines of patent exhaustion, I can do whatever I want with the seeds. If I buy an appliance that is patented, I can do anything I want with it. I can use it as an appliance, I can chop it up, I can sell it, I can do anything with it. Once I own the thing, that's the first sale, and the patent has been exhausted. That is, as a matter of logic, the law. But what did the Supreme Court say in Bowman versus Monsanto? Contrary to its refusal to recognize the importance of investment in the Marriott case, it said, well, we can't let this happen. Anyone who listened to the argument would know after 45 seconds that Bowman had lost, because the first question out, I think by Justice Breyer, was, well, if anyone can get these seeds and plant them, why would Monsanto ever have invested money in creating them? Exactly the relevant question for why would Marriott have ever developed the isolated DNA gene. But in that case, it was critical to the U.S. Supreme Court that Monsanto had made the investment, and that the investment